Good morning. Welcome to our KTI webinar this morning, our first one of 2022. And we're very pleased to have such high numbers today. We have over 200 registrations for this very interesting topic on patenting. And we've gotten a lot of questions from the audience, so we know that you're really interested in this, and we welcome any questions that you may have throughout the webinar. We've brought together an expert panel this morning, and I'm going to introduce them now. So we have Margaret Lawler, Life Sciences Case Manager from the University of Limerick. We have Dermot Roach, Patent Director at Cicerna, and we have John Whelan, ICT Research Commercialisation Case Manager at Trinity College Dublin. So our experts are on hand to answer any questions that you may have, and they're also going to give their views on developments throughout the patent landscape over the coming year. So you have a Q&A box on your screen, so you can submit questions at any time. The format of the webinar this morning is going to be a panel discussion followed by a Q&A, so please do get your questions in. So with that, I'm going to pass over to Vincent Wall, who's our moderator for this morning.
Thanks indeed, Siobhan, and good morning, everybody, and Happy New Year to you all. And I hope it's not just a New Year's resolution that so many people are actually tuned in this morning, and that it's more a sign of the great interest there is in this particular topic of patents, white patents, and the trends in patenting across Ireland and Europe. And we have wonderful and very expert guests here, as Siobhan said, to take us through some of these issues. So I might start with just an overall high arching question, folks. Why patents? Why should research teams in universities, why should companies large and small think of getting patent protection for their products and services in the first place? I might start with you, Dermot.
Hey, Vincent, thanks. So there's probably quite a few different reasons related to the strategy of the business, the organization, as to why they might be interested in a patent. The sort of the traditional role of a patent is acting like a fence post to define a particular market share, so as to kind of exclude competitors. So that could be an implicit sort of discouragement or a barrier to the competitor from entering the market, or it could be actually explicitly enforcing the patent with a court injunction. Another way that a lot of businesses use patents are actually, instead of trying to exclude competitors, to try and encourage a lot of businesses to use the technology and to gain by licensing the patent to those companies, and in return, obviously, to receive the royalties. So that would be a very important use also. Some businesses use them as a kind of a defensive leverage. So, for example, if company A had a patent on one part of the technology and company B had a patent on a different part of the technology, A might be discouraged from bringing an infringement action against B because they fear that B might have a counter action against them. So having a patent portfolio can be used in a defensive sense as well. I know a lot of the people today listening are kind of maybe from the SME market or the startup market, and for SMEs and startups, the really big benefit of protecting patents is to give that negotiation position and to build value in the company. So it might be that they need to establish a partnership with a larger company to fund clinical trials, or to expand manufacturing, or to help distribution. And by protecting their new ideas and their research, this is a way to build kind of real value in the company, so that when a potential investor or potential partner comes in, they have a real asset that they can actually try and invest in. And that would probably be the really, really important reason for the kind of the startup and the SME market.
Is it, John Whelan, is an essential element of the whole encouragement move towards innovation in Irish industry, in Irish academia, that and I even heard Enterprise Ireland Chief Executive Leo Clancy referencing it this morning with the organisation's results, is at least the possibility or the option to take out a patent go hand in hand with innovation in terms of protecting that investment, as Dermot said?
Yes, absolutely, Vincent. I mean, patents are very important, but they're, I think at a high level, to put some perspective on it, they're a tool. They're an important tool to protect assets that the company has, and innovation, intellectual property can be the most important asset that a company has. But people think in technology transfer, for example, or knowledge transfer in universities, that all we care about is patenting, and they're just a tool that we have in our toolbox that we use to protect intellectual property for spin-out companies and for the university. But they're anti-competitive. It's a monopoly right, but it's there for a reason. It only lasts for, as we know, 20 years. And then it's given back to the community. So we see it with drugs, when drugs become off patent and you can get a generic drug. So it's a really unique system. But I know there's a lot of, we see, you're talking about trends today, we see a lot of resistance from people, particularly in the software world. There's a big movement against patenting, and there's a balance. There's a kind of a dialectic between open access for data, open source, open publishing, and then protecting your rights. There's a dialectic there that's very interesting. But it's definitely something that any startup, any SME should be aware of and should deploy where necessary.
Should explore, and we'll be coming to some of the specific dynamics of, I suppose, of the whole and growing area of software, and whether protections or licensing should be part of that strategy or not. Margaret, Dermot referenced there at the start that it can be a source of income as well, and you have some examples of that in terms of getting licensing income from your patent protection.
For sure, and I have a personal experience. I managed a patent portfolio in a company for a number of years, and one of the patents we managed, we were a small manufacturing company traditionally, and I should say that we merged. During my lifetime there, we merged with another company, and we did it because we had competing patents, and rather than compete against each other, the companies Access and Chemicals and Shield Diagnostics merged to become one company. So it led to a merger. But during my time there, we also had a patent to measure HbA1c, which we sub-licensed and in fact manufactured the product for a number of other companies. And at one point, if your HbA1c was measured by immunoassay, there was a 50% chance that you were using our intellectual property. And it became a significant source of income to the company. It wasn't our primary objective, but at one point for the company, it was up to 10 to 15% of our income came from sub-licensing rights. So it can be it's very important to protect your intellectual property, because it can actually earn you money. And certainly what we spent on our patent budget would have been significantly less than the income we were receiving. Now, it wasn't like that for all of our technology, but it was important.
Before we get into some of the specific issues and trends that are happening in this environment at the moment, I suspect, as somebody who is non-expert and people who are looking in, who are attending today, I said one of the key questions before we go any further is just the whole question of cost, particularly for SMEs. And you referenced that you worked for a small manufacturing business at one stage, Margaret. That whole issue of cost, is that a formidable hurdle for smaller companies?
Oh, it is. And I mean, if you look in Europe, of the 180,000 patents that were filed in 2020, 75% are from multinational companies who have big budgets. And a patent is a commercial decision. So when you're thinking of patenting, you really do need to look to see where are your markets. And indeed, is it worth patenting? There are some technologies where maybe the lifespan may be so short that it may not be worth your while patenting. So you have to look at your product, what's the lifespan of your product, and where are your major markets. And patenting should always be a commercial decision. It's not a nice to have, it's a commercial decision to protect your product in your major markets.
John, any views on that?
Absolutely. It's a commercial tool, and it's, as you say, it's a marker down in the sand. Investors, in particular US investors, will always look and expect a patent. So for a startup, it goes on your well, I'm not an accountant. I'm not sure if it goes on your balance sheet,
Yeah.
but it's a tangible. It turns in, you know, intellectual property is intangible, so it turns it into something tangible with a number. But yeah, as Margaret says, the process, the cost. I think in Ireland we have a great system through Knowledge Transfer Ireland and the networks, that there's a number of patent attorney firms in Ireland that work very closely with startups and with technology transfer offices. And I think in Ireland, the costs are very reasonable. Sometimes you see a startup, you know, you go to the Web Summit or Flush in Helsinki, you meet a startup and they've been charged €20,000 to do a patent. And it's a huge, you know, to do a first filing. And that's really crippling for a startup. The system in Ireland is quite mature, and patent attorneys, I mean, Dermot can speak on this, they see the opportunity to work with startups, because, you know, if you file the patent for a startup and then they become a unicorn, well then, happy days for everybody, you know.
Well, just on that point, Dermot, and I know Cicerna, you're heading up a new office for Cicerna in Ireland, specifically in this whole area. You know, in terms of the cost, in terms of the cost benefit, particularly for smaller companies, what's your point of view from a commercial legal point of view?
Absolutely. You know, it's vital that a budget is set aside and a realistic appraisal is made as to the costs over the coming years. So there are two sort of parts to patenting cost. One is the initial filing cost, preparing and filing the patent. And then once that's submitted to the patent office, there is a process that goes on, typically for a number of years of examination and getting the patent fully approved. Sometimes that's known as patent prosecution. So there's two kind of parts to it. And it is vital that companies look ahead. We've got costs depending on the country as well. As Margaret talked about earlier, the markets. It's important, again, to have a realistic plan as to what countries am I trying to get a patent in. There's no such thing as an overall worldwide patent. So it's important to sort of pick. My key markets are going to be, for example, US and Europe. And I'm going to make that decision, and I'm going to consciously decide not to, you know, pursue patents in the Far East. So having that plan is key. And also saying to yourself, well, you know, I'm developing a product here, I'm developing a business. It may be that in year one, I have the first invention, the first innovation. It may be 6 months, 12 months, 18 years later, the product develops and I have a new innovation, so that you could have multiple parallel patents ongoing. And as I said, that could be in multiple countries. So the cost could very, very quickly multiply. So it's, as I said, it's key just to have that plan in place as to how you're going to fund that.
And so it sounds like you not only need a budget, but you also need patience, because it can take time.
For sure, for sure. I mean, it's going to take in Europe or the US, for example, as probably the two most important markets for companies that are Irish companies. It's going to take a number of years, typically, from the initial filing of the patent until it's fully approved. In Europe, the average is something around maybe 3 to 4 years. In the US, similar average, so maybe slightly less. So of course, that means in some cases it takes significantly longer if that's the average. And again, it's a matter of having a realistic plan in place. But sometimes people say, gosh, that's really negative that it's going to take me 3 or 4 years to get a patent granted. It could be a good thing or it could be a bad thing. Obviously, you want to have your patent fully approved so that you're in a stronger position, maybe licensing it or enforcing it against a competitor. But equally, putting off the costs and putting off the decisions can sometimes be very important, especially for an SME or a startup. Submitting the patent is the really key initial thing. It allows a company then to go and talk to potential suppliers or potential partners. But maybe putting off the costs can be a good thing for an SME or a startup, because it means the patent is still fluid. They still have the protection on the way, but equally they're putting off the costs.
I might just stay with you, Dermot, because you referenced there that there's no such thing as a worldwide patent protects you in every territory. And you also referenced that Europe is key and growing market for Ireland. A lot of questions obviously coming in, and this is a key area in the whole patent discussion. what's happening now at an EU level in terms of bringing in a unified system across the EU. Where are we on that?
Yeah, so the current system is that you can apply to the European Patent Office and have a European patent granted. And that's not just the EU, it's bigger than the EU. It includes still the UK, it includes countries like Switzerland and Norway. But once the European patent is fully approved and granted, it then becomes a bundle, and effectively it becomes a patent in each individual country you're interested in. So they're going to make a change probably very soon. It could be as soon as the end of this year, early next year, where they're going to introduce what's known as a unitary patent, which means just one single patent for all of the EU. They're also going to make another change of introducing a single patent court, which covers the EU. It's going to be called the UPC, the Unified Patent Court. So again, at the moment, if I had a patent in the UK and I had a patent in Ireland and one in Germany, even though they all came from the same source, this European patent, and if I wanted to litigate and enforce it against a competitor, I'd have to go to each individual country. So that's going to change with this new Unified Patent Court. So there are two fairly major changes. Both are adding new options. They're not taking away any options. The European patent system with the bundle of patents is still going to be there. The national patent courts are still going to be there. So it's just adding another option for how you can protect your patent or how you can try and enforce it.
But two supplementary questions there. I presume the benefit of that when it goes through or when it's launched is both administrative ease and lower cost. And secondly, is it the case that we in Ireland are holding up the implementation of this new unified system because it needs to go to referendum here?
Yeah, so the main reason for having this new system is to look at reducing costs if possible, and also looking about harmonizing the law. So if you imagine you have a single patent court in the EU which makes the decisions, it's a single clear definition of what the law is. Occasionally, you have situations where a court in Germany and a court in, for example, the UK come to a different decision at the moment. It's fairly rare, but it can happen. So that's the main reasons for harmonizing and looking at the costs. Then on your second question about Ireland, so we have agreed that we will sign up to this new unitary system, but so far we haven't done so. And the big reason is that we need to have a referendum in Ireland to actually approve this new unified patent court, because we're ceding part of our jurisdiction on patent matters to this new court. So it will go ahead without us, and probably as early as the end of this year. It's probably unlikely that we'll have the referendum and have approved it by then. I mean, it could happen. If it were to go ahead without us, we can of course join it later. But at the moment, it looks like it'll go ahead and probably without us, unless things move very quickly.
And if it goes ahead without us, that still means that Irish academic-based researchers or companies could still avail of this, even though, you know, it's just that the system wouldn't be implementable in Ireland.
Exactly. So at the moment, even a US business can always try and obtain a unitary patent, or if they wanted, they could enforce their patent in Europe through this UPC. And Irish businesses, Irish startups could do exactly the same. It just means that we wouldn't have this option of the unitary patent extending to Ireland. We would have to still get the current system of having the European patent and then validated in Ireland.
Yeah, and Vincent just said, I mean, Ibec are really pushing the government on this topic, that it's a big opportunity for Ireland politically, economically, that we, you know, with Brexit and London, the London section could be moved to Dublin. And Nisha Gaffney, who used to work in our office, big plug for him, he's really pushing this. He works with Intellectual Ventures now. So there's political pressure on the government, but Dermot may or may know whether that's going to come to fruition, or Margaret. Yeah.
And for sure, it would be really beneficial to us if we could have one of the local division courts in Ireland. It would, you know, it would help our SMEs, because we'd have expertise on hand. It would help improve the cost, and it would raise our profile. I mean, we're now the only English-speaking country with a common law. type of law in the EU. So it could certainly, I think, help us and raise our, I mean, imagine the jobs it could bring to Ireland, you know, if we had a division of court here, it would improve our expertise in this area. So I think it would be of great benefit to Ireland.
What are the implications if this goes ahead for, because I was just looking at the latest Knowledge Transfer Ireland statistics in terms of where both academic institutions and companies seek patents, and a very high proportion still in the UK now. I think these are 2019 figures, but a very high proportion in the IPO, the Intellectual Property Office in the UK, over 40%. Is that going to have implications, do you think, for where you direct academic researchers, campus companies, or SMEs to seek patent protection at the moment? That has Brexit influenced that, or will people still seek and should seek IPO protection in the UK as well, because it's a significant market?
Yeah, it's a significant market, is the answer to that. And it remains a significant market. And the UK is within the patent, so it may not be part of the EU anymore, but certainly within the European patent protection, it falls within that jurisdiction. So the UK, I think, will remain an important market for Ireland, for sure.
Any implications, John or Dermot, for you, where you would perhaps direct clients or research bodies to seek protection, to seek patent protection with this new unified system coming in the EU?
Well, assuming that it's there, obviously you would use that system. But you know, the first filing, the priority filing, isn't that important in many ways. Where you go for, very often you would file. We would often file in the UK because you can get a basic search report quite quickly. And, you know, the system, it doesn't really matter. I think the Irish Patent Office, unfortunately, has been underfunded for years. So most people would file in Europe. We would move, or the UK, it depends, you know, it depends on the market. It depends on whether you want to get a good search report quickly. There's lots of variables, yeah.
So speed of decision may be a reason why people go outside of Ireland to either the UK, EU, or America. Well,
depends. As Dermot said, sometimes you don't want a decision, a quick decision. You know, in Europe, there's the patent prosecution highway. There is a new method you can accelerate, and I think there's something similar in the US as well. But you know, just to say, from the university point of view and research institutions, and Margaret will agree, I think the cost, we would always not, you know, the cost does rise over time. It does rise almost exponentially in the first 3 or 4 years. It's particularly if you want to get protection in many different countries. So our policy, and I'm sure UL is probably the same, is to license it to an Irish startup, ideally a spin out, before it gets expensive. But that spin out must have raised venture capital, and they normally will have. So the venture capital will take on the risk. The venture capitalists, the investors, will take on the risk of the exploitation, and they will often file more patents. Particularly US investors will say, okay, we've got to ring fence this new work being done. So it's a commercial decision. Everything about patents is commercial. It's a tool that you use.
And the US would still, I would say the US and Europe are still probably the two biggest territories where people file. The US remains the #1 country, or country where people will file their patent, and it's closely followed by Europe. And it's always around markets and commercial decision.
And as John referenced there, Margaret, it's frequently a decision either encouraged or taken by investors in a particular vehicle as much as the management.
Yes, and in fact, actually, I mean, for spin-outs, and I'm sure John will agree here, that a patent is often a key requirement for investment. So investors want to make sure that their investment is protected in the big markets. So they will, I mean, I'm seeing more and more due diligence now from investors where they'll want to see the search reports. They'll want to see what are your chances of getting this patent through, what freedom to operate do you have. So investors are more and more looking in to see what is your intellectual property, how is it protected, and what is the strength of the protection you can get.
We referenced, I suppose, some of the key areas where people may, where companies and research bodies may seek patent protection at the moment, be the UK, be it Europe, be it the United States, obviously, and at home. The whole issue of China, how important China is becoming in terms of a threat to people's inventions or unique products. And then, of course, China as a market as well. What sort of patent protection can you get for selling your service or product into China? Margaret, I think you have a particular interest in this.
Yeah, it's interesting. I mean, I will be honest with you, sort of 10 years ago, I would never have thought of patenting in China. And certainly as an academic institution, like even 5 years ago, I really wouldn't have thought of patenting in China. But we've had a patent grant in China with one of our spinouts. And again, it's I mean, as the first market is still probably the US and Europe, but China is certainly taking over. Whereas, 5 years ago, we might have thought of Japan or Canada. Now China is probably the third option. But again, it depends on your budget, and you always have to be realistic. But we're finding that Chinese companies are now they're demanding and asking for. So if you're moving into China, or there's more and more investors coming from China looking for intellectual property, and they're very a patent is key to protect their investment in China, to protect their investment from other Chinese companies. So whereas 5 years ago, I wouldn't really have thought of China, even within China now, and as the Chinese government is starting to protect intellectual property, it's worth considering. But again, you must look at your budget. What is your budget, and where are your key markets, and how long is it, how big is your market, and how realistic is it? I mean, do you have a good network in China? Do you have distributors in China? Do you have investors in China? So again, it must be a commercial decision, and how likely are you to actually sell product there and make profit in China?
Dermot, any thoughts on that?
Yeah, I mean, filing in different countries has different issues. I mean, some countries, filing a patent, the examination process may take an extremely long amount of time because the system isn't well set up in the country. China is not one of those countries. The patent will be examined. It will be examined in a way which is familiar to sort of businesses from the US or from Europe, and they are granted in a reasonable amount of time, like the kind of timeframes I talked about for Europe and the US. So from that point of view, it is a process that will come to an end in a fairly satisfactory manner. The other big issues to think about with other countries are translation costs. Again, coming back to costs we talked about earlier, for China, for Japan, there are significant translation costs. China is reasonable though when it comes to costs. It is not excessive. Japan can be quite a lot more both to file the patent, and then this process of examination I talked about to get it through to a final grant stage can be significantly more expensive. So many of our clients do file in China. It's not an exceptional thing, far from it. China-based businesses are now the #1 filers of patents in the whole world. There are more patents filed by inventors, innovators from China than anywhere else. They don't file large percentages outside of China. So in the US or Europe, we would file patents in our local territory, and then we would often file in countries outside. Whereas in China at the moment, the percentage filing outside of China is relatively small. But because of the numbers, they're literally filing over 1 million every year. Even the percentage of that is going to come over to places like Europe. So the Chinese businesses are getting protection in this part of the world as well.
Yeah, certainly it sounds like it should be on everybody's radar, at least. Before we come on to the very important topic of digitization and software and how that's changing the game, if it is, there's one comment here from one of our attendees. She says that an applicant at the Irish office will typically get their research report and written opinion, which is conducted by the UK patent office within 3 months of paying the search fee of €200. So that's obviously based on experience there, that obviously the UK office infrequently does the search for the Irish office, but that you can get a relatively quick response initially anyway, and that's an important point to make, I suppose.
It wouldn't be as great quality. The UK patent office are great people. They're lovely people. They're based in in Wales and the south of Wales and Newport. So you can call them up and, you know,
They're
have a
hotels.
they're really nice.
Yeah.
But yeah, the quality, I mean, the quality of a European search report would be the kind of gold standard.
Gold standard.
That's an important point to make. Yeah.
I mean,
Yeah.
it depends what you want. I mean, but an early one after 6 can be very useful to know before you proceed to the later stage and continue the prosecution.
Test the water, so to speak.
Exactly, yeah.
I suppose traditionally we've looked at patents in particular as distinct from other ways of protecting your intellectual property as for inventions, or amendments to physical products like medical devices or whatever. The whole area of digitization and software, John, how is that changing the nature of whether people should be looking for patent protection? Is that the route to go or not?
Yeah, that's a very good question and a very complex question and an evolving question. It changes by case law very frequently. And I mean, 3 or 4 years ago, we would have said the general rule of thumb was you can't really file software, you can't protect software in Europe, but you can in the US. That's changed a bit lately, and there's a lot of case law in the US. Alice, Bob, Bilski, Dermot will know all these cases far better than I do. But the trend with artificial intelligence a couple of years ago, and it was Purdy Lucy that we use, Michael Lucy, that we've often worked with as patent attorneys, sent a presentation from the European Patent Office about how to patent artificial intelligence, machine learning. So European Patent Office, and it's at a simplistic level, did jump ahead and kind of said, okay, we're open to this. We see an opportunity here. And then they were followed by the US, ironically. So the state of play at the moment is, particularly for software, it's worth doing, but there must be a technical effect, So if it's in telecoms or something where there's a physical, it's not just data moving around on a computer, there's radiation, there's electromagnetic waves, that's well known. So it's possible, but if it's a financial, somebody had already asked the question, fintech would always be difficult because there's no tech, it's hard to find a technical effect. In AI, I don't know if you want to talk about this. We could
a little bit, because
a little bit. I'll keep it short. There were other questions previously that Siobhan had about artificial intelligence, machine learning. This is even more complex because the training data, the real value in an artificial intelligence system is usually the data that trains the system. So you've got a medical problem, we have a big project in Trinity for motor neuron disease that just kicked off with 5 million from a lot of big pharma companies in the US, and the data is the most valuable thing there. So there's a set of European data with motor neuron disease cases and treatments and outcomes. But who owns the data? So the data has to be separated. You cannot patent data. Data is protected by copyright, by database rights, sui generis database rights. So that's where the value can be. So you must make sure, if you're in a company, that you have the rights to the data that you're using to train your algorithm. You can protect the algorithm provided there is novelty, and there's utility, and it passes all the technical effect tests. So it's evolving, but it's definitely worth looking at for a startup with software, because the US companies, Silicon Valley, they do it all the time. And that's what you're up against when you go looking for big investment outside of Ireland.
Dermot, Margaret, any views on this in terms of the changing digital world and software protection in terms of John's points there?
Yeah, it's growing. It's certainly a growing area. And if you look in Europe, it's medtech has led in the number of applications. So the filings from the medtech industry have, for the last 5 to 10 years, has been the big area of growth and continues to grow. But certainly communications, ICT, it's growing. It's a growing area. And I think if you have a technology now, it's definitely worth looking to see if you can get patent protection. But again, because remember, a patent doesn't give you the right to, to manufacture or use something. A patent is a negative right. It stops others from using your technology. And I'll be honest with you, one has to realize that there are so many patents out there now that it's probably very difficult for people not to infringe, or freedom to operate is a difficult issue. And certainly even with these, with the ICT patents and the algorithms, there are more and more patents out there, but you still, as I said, it's a commercial thing. You do need to protect your intellectual property. So it's definitely something you should consider.
Dermot?
Yeah, and I mean, again, for Irish-based innovators, for Irish companies, you need to think in terms of potentially going for patents in countries other than Europe. The US is probably going to be an easier route if you're looking at a computer implemented invention than Europe. And it is really important, especially as we're hearing there, getting protection in the US market if you're looking to engage with investors. The issue in Europe can be more difficult to get a patent, but patents are granted for inventions which relate to computers, to software implementation. Thousands of patents are granted in Europe every year, which involves software at some level. But it's key that the technical effect, as John mentioned, is a feature that you can present to the patent office examiner to convince them that it's not just a sort of an administrative or a financial innovation, that it involves an innovation to do with solving a technical problem with how the system is going to operate. So it's just important to keep in mind that it's going to change slightly in different jurisdictions.
So it's an evolving situation as well, by the sound of things. And you referenced at the very start, John, that in particular in software, there's a debate going on as to whether patenting is the way to go, or whether there should be open sourcing of knowledge. But even within the broad licensing stroke patenting environment, there are all sorts of sharing mechanisms between different entities, the standard essential patents and the like.
Yeah, again, a very complex area, but the trend in software is hugely towards open source. 80% of all software being written today in the world is open source, whether that's within the large big tech, within Google, Microsoft, or just in smaller startups. And it's a phenomenon, and it does, a lot of open source licenses do include patents. Patent coverage is included, and that's actually some of the nuanced differences between some of the different open source license that you choose. But the commercial, again, everything we do in knowledge transfer is about commercial benefit to Ireland, social and economic impact, and creating a knowledge economy. So open source, we have several, 10 years ago, we licensed, we allowed an open source spin out from Trinity Software Radio Systems in Cork, who are doing very well at the moment. We recently had Terminus DB spun out. We've set up an open source program office within our office. We want to encourage academics to see, researchers love open source because you get the code and you use it and you can improve it. And it's great for the economy, but there has to be, as I said, there is a paradox of the business side, but there are business models built around open source, which work very well, starting with services, training around the open source, that you're the expert in it, right down to core, where you keep the core code is open source, but everything around it is proprietary, so you can be quite clever there. So it's really the way forward in software. And SFI has made it a mandate now that all research that they fund in institutes of technology and universities must be published in open access journals, which means it's available to the community. Now that's slightly different to open source, and there's an important difference there, but that's the trend. We're seeing it with the vaccine production, but there still has to be a commercial benefits. People won't invest billions in creating a vaccine
Yeah.
if they get if they have to give it all away for free. So it's this balance.
Yeah, I was just going to put that point to Dermot. I mean, I can understand the philosophy behind what John is saying there, and particularly the software community. But on the other hand, if a large or even a peer-sized competitor can basically leapfrog on your research time, innovation time, it could be seen as an inhibitor of investment in research and development.
And I think that's the basic reason, coming back to your very, very first point, why would you want a patent in the first place? The really basic reason is if you put a lot of time and effort into developing a new technology, and you either make it open source, for example, or even you just put it on the market and some competitor gets to obtain the product and reverse engineer it and work out what you've done. If you've put a lot of time and effort in, and your competitor can either just read it on an open source document or reverse engineer it, they could save all of that time and energy and potentially put the product on the market for a more attractive price. That's the really basic reason for having a patent in the first place, to protect all of the effort you've put in so that you can recoup some of those costs and that effort when it comes to a commercial arrangement. We talked about at the beginning, it could be defining a market share, it could be having a licensing revenue, but ultimately that's what we're trying to do with a patent.
I think we've established how important this whole area is for companies and research teams to at least explore, depending on the product or service that they have, the kinds of markets that they're going to sell into or are selling into, the various options that are there in terms of where you may get a search more quickly or more thoroughly, depending on your priorities. The whole question then, and I'm looking at the time, we probably have about 4 or 5 minutes here. The whole question then of supports for research teams in academia, for companies that interact with our universities and technological institutions, and obviously for commercial firms as well, Dermot. The kinds of supports that are out there, and as Knowledge Transfer Ireland, importantly, is our host for this whole debate, it's important to point out the supports that are out there from both Knowledge Transfer Ireland and Enterprise Ireland. So lots of practical guides to managing intellectual property strategies and confidentiality, that whole area, practical guides and model agreements, types of agreements that are out there that are anonymized, but that are out there already that people can follow and see if it's right for them. There's the intellectual property strategy grants on offer from Enterprise Ireland to actually develop a strategy to build up the competencies that you mightn't have in the company itself, or to bring in external advice. There are grants out there, intellectual property strategy offer grants from Enterprise Ireland. But talk us through, both Margaret and John, initially, the technology transfer offices in the universities that you represent. Are they only for academic-based researchers, or do you interact with companies in your catchment area as well that have ideas that want to partner with you?
I mean, again, I'll take that, but I would reiterate that we are very, very lucky in Ireland. So Ibec have an IP working group, the National Standards Association of Ireland have a whole series of standards now. So if you're a company and you want to learn about IP and set up an IP management system, there are a whole series of standards available now, and they're really, really useful. They're worth reading through. We have Enterprise Ireland, a huge number of supports. In the university, look, as a tech transfer office, our main objective is to work with our academics to help them to manage their IP and to get, the best value for Ireland, and to make sure that, they're using their IP for the benefit of the Irish people and internationally for the benefit of people worldwide. So our primary objective would be to work with our academics. But for sure, a lot of our academics do set up spin-out companies. We do work with our spin-out companies before they spin out to help them to set them up. We'll help them with their IP strategies. We'll help them identify their IP, help them with their markets. And again, there are some really valuable grants from Enterprise Ireland, the commercialization funds, that can assist academics who have a commercial idea and think they may have something that is, could become a spin out and add to the Irish and global economy. So there are a lot of supports there. within most of the universities ourselves, I mean, in UL, we have an incubation center, the Nexus Incubation Center. And within the Nexus Incubation Center, there are some of UL spin-out companies are housed there, but also other startup companies that have nothing to do with UL are housed within there, and we provide them support. So our Nexus incubation team, they will introduce them to patent attorneys, tax consultants, and other experts that startup companies would need to interact with. And most of the universities in Ireland will have such supports available to SMEs in their local area.
John, I presume you're of the same mind?
Yes, absolutely. I mean, I think a lot of innovation comes not just from academics, researchers working in an area, but by collaboration with industry. So when a researcher collaborates with an industry partner, be they large or small, tends to be the larger companies that fund collaboration projects. That's where the real magic can happen. And, you know, that's where the great ideas come from. But as Margaret hinted at, it's about the ecosystem, particularly with startups. We would work with a lot of startups that would come with an idea, and really we would match them up with a researcher. And that's a hard thing to do. A researcher would, you know, a researcher has been working in an area, but sometimes they can really gel. Sometimes they say, wow, that's a really interesting problem. I think I've got an idea at how we can solve that. And then we get the Enterprise Ireland funding for the commercialization fund. The IP can be managed in a certain way. So it's essentially, it's a kind of a spin-in kind of, you know, we've worked with pilots from Aer Lingus who describe problems that they encounter every day. I remember a pilot from Aer Lingus talking about bird strikes before the Hudson River disaster, you know, talking about other problems. And they're the people on the ground that can really, you know, needs-led. It can very often be needs-led innovation, but it needs the fundamental research that's going on. If you look at something like quantum physics or quantum computing, you know, there aren't many startups that are in a lab doing quantum computing, but they may need the resources that a university has. So that's when things can come together, and we can file joint patents. You know, we do a lot. One of the metrics internationally is how many joint patents does a university file with industry, and that's a good measure of how well you're doing, I think.
Okay, and I won't ask you competitively between UL and Trinity. We'll keep that for
another day. I was going to say, for sure, a lot of what we do is working with our academics and local companies, international companies, to support collaboration. So it's not just about patents and filing patents. In fact, the vast majority of what we do, and there's nothing nicer than when you can match up a company with an academic and they work together and you're solving real world problems. So, I mean, really the universities are a massive resource with our massive repository of knowledge, and you know, one of our objectives is to get that knowledge out there into the world, and one of the ways we do that is by working with companies, be they startups, SMEs, large multinationals.
And Dermot, I'll leave the last word with you. Outside the world of academia, you're obviously targeted on the purely commercial world, if I may call it that, large and small companies. You know, for companies that are out there, small or large, and particularly SMEs who might think this is cost prohibitive, you know, what's your advice in terms of what a patent attorney like yourself can offer in terms of advice and bringing people along this journey? Yeah,
absolutely. And you know, we and my colleagues in other patent attorney firms, typically the first discussion with a new client, a startup or an inventor, you know, we're happy to discuss with them, to give them an introduction to the options available and to propose what steps they need to take. A lot of them along the lines of what we talked about earlier. When it comes to financial support, you mentioned earlier all the really super sort of information support on the KTI website, etc. When it comes to financial support, there is help available from, it's been mentioned a few times, from Enterprise Ireland, but also from, there's a lot of good links of financial support on the IP Office of Ireland and on the EU IP Office. There are schemes in place to help with the costs of filing patents and other types of IP rights like trademarks and designs, to help with the costs of conducting an audit of a business, so that somebody like myself could go in and say, look, what do you have? What steps do you need to take to protect that IP? There are also other financial means of trying to support this journey. There are sort of tax advantages to do with things like the R&D tax credits, and there's something called the knowledge development box, which is all about trying to reduce corporation tax when there's patented inventions in place. We've also mentioned several times funding from venture capital, whether they're sort of the halo business angels, whether they're the large, more commercial funds, or Enterprise Ireland taking the venture capital approach. So there is lots of help available. And I think it comes back to what we were talking about earlier, of having an IP budget and a plan in place as to how to fund this journey.
And very briefly, Dermot, the whole issue of if things go wrong, litigation, is it a regular occurrence?
In Ireland, patent litigation is fairly unusual. You know, you're talking about cases going to trial in Ireland, certainly less than 5 a year. In other jurisdictions like Germany or the UK, it's more frequent. And the US would be the major source for patent litigation. The legal systems are a little bit different, and the business culture is a little bit different. But litigation of patents is going to be a very, very small percentage of the number of patents granted every year are going to be litigated, way less than 1%. So it's not the overall goal of having a patent. What we talked about at the beginning, there's lots of reasons for having the patent, and actually litigating in court is going to be very much the last port of call, and only for a very extreme case.
On that very positive note from a lawyer, we leave it there, folks. It's a fascinating area, and obviously an evolving area, and quite complex in some ways in terms of not just practicalities on the ground, but as John referenced there, even the philosophy of sharing or protecting and all of that. But thanks indeed for joining us, Margaret Lawler from UL, Dermot Roach from Cicerna, and John Whelan from Trinity. And I'll hand you back to Siobhan. If you're there, Siobhan.
I am here. Thanks, Vincent. We've run a few minutes over, but that was a really interesting discussion. And I think we probably could have gone on for another hour at least to cover all the topics. And we'd really like to thank you for all the questions that you've submitted in advance and during this webinar. There's a lot of interest in this. If there is a topic that we haven't managed to cover during the discussion, please feel free to get in touch with us at KTI and we can send you on the relevant information. And also, if you do have any feedback, we'd be very interested to know that. If you're interested in us holding another session on this topic, that's something that we're willing to do as well if there is some interest out there. So with that, I'd really like to thank our panelists for this morning, Margaret Lawler, Dermot Roach, John Whelan, and our moderator, Vincent Wall. Our next webinar is going to be on the 8th of February, and we'll be covering the topic of sports technology. So we hope to see you then. Thanks for your time this morning. Bye.
Thank you.
Thank you.
Thank you. Thank you.
Bye.